And I will introduce our next speaker. It's actually a panel on state court litigation saved Wisconsin wolves, from Jessica Blome of Greenfire Law, Claire Lobes Davis of Animal and Wolf Advocates, and Melissa Smith, Friends of the Wisconsin Wolf and Wildlife. And I will introduce each of these speakers. Jessica Blome is a partner with the public interest environmental law firm Greenfire Law PC. Jessica practices in the areas of animal, environmental, open government, and land use law. She represents citizen groups and individual plaintiffs in local, state, and federal tribunals in California and across the country. Claire Lobes Davis is the founder and managing partner of Animal and Earth Advocates, a Seattle area law firm that works on behalf of animals, wildlife, and the environment. Claire has brought several lawsuits challenging state wolf management in Washington, in addition to the one in Wisconsin that the panel will discuss. Claire has brought a wide variety of other litigation to protect the environment, wild fish, and terrestrial wildlife, including suits to stop the logging of old-growth forest, curb grazing on public lands, stop hound hunting, challenge carnivore hunting rules, and protect wild fish from the dangers posed by aquaculture and hatcheries. Claire is also the board president for the nonprofit Washington Wildlife First. She's actively worked to reform Washington's wolf management policies, including advocating for a rule that would limit the state's ability to use taxpayer funds to kill wolves as a result of livestock predations. And our third panelist, Melissa Smith, founded Friends of the Wisconsin Wolf in 2011, shortly after wolves were delisted from the Endangered Species Act for the first time in Wisconsin. Her professional and personal mission is to have wildlife governance that considers all members of the public. Melissa served as an elected delegate to the Wisconsin Conservation Congress for 8 years. She is a sociologist and has worked as an organizer and lobbyist for other national NGOs, such as Endangered Species Coalition, but always felt that the Great Lakes region was treated as a flyover zone that needed special attention, a rebirth and preservation of wildlife and wildlands. In 2015, Melissa formed the Great Lakes Wildlife Alliance for the purpose of fighting for and making the Western Great Lakes states leaders in wildlife ethics. And her favorite animal is the raccoon, which I mentioned because you may see a raccoon guest appearance here. All right, I will turn it over to the panel now, and I'll stop sharing here. You are muted. Hold on.
Good afternoon and good morning to all of you. Let me just get this screen share, make sure I'm doing this correctly. Everybody can see that okay? Maybe this little bar can go away. I don't know how. Okay, is that looking fine?
Yep, looks good.
Okay, good. All right, well, thank you all for coming. I guess I am starting first, coming to you from the Ho-Chunk Nation lands in Madison, Wisconsin. I'm Fran's neighbor. So we're gonna talk to you today about state court litigation and how we saved Wisconsin wolves. I'm gonna be relatively brief, as I'm sure you wanna get into more of the litigation talk, but I've got to try to move this up. There we go. And again, our organization, Great Lakes Wildlife Alliance, is also Friends of the Wisconsin Wolf, that we're one and the same, but we did form that to include more wildlife than just wolves, as I'm sure all of you probably care about all wildlife and not just wolves. Just go through here. Oh, did I miss one? Okay, and again, I think there was an introduction for Jessica and for Claire, who were our attorneys that we hired. Do you need me to keep going with the introductions, Jessica? Probably not. Okay, just gonna go rather quickly. And I was told yesterday, I talked to someone from Montana on the phone and said us Midwesterners speak too fast. So I'm intentionally trying to slow myself down here. I just can't see my own side. There we go. There we go. So I'm Melissa Smith, the executive director. We do have two websites. One is a kind of bigger issue, kind of reforming all of wildlife U.S. Fish and Wildlife Service, our own Wisconsin DNR, and all the agencies nationwide. That's more what Great Lakes Wildlife Alliance does. We're Friends of the Wisconsin Wolf is really a more local, and we're fighting. Obviously, we've got wolf in the name. Some of the things we do are trying to reform our Natural Resources Board. We do organizing. We try to promote scientific integrity. We have an awesome scientific advisory board. We do community outreach and try to build coalitions, even with hunters that seem the way that we see things. And now, of course, litigation. And there I am protesting something like I do every day, feels like. Okay. So I guess I just want to give you guys some background on this, at least from like an advocacy perspective. In Wisconsin, we have a law on the books, and it's the Wisconsin Wolf Hunt Law, Act 169. And so the state of Wisconsin does mandate that if wolves are not listed, we must have a hunting season. And that's our law. You can kind of go down there. For hunting and trapping of wolves, we allow the use of dogs to hunt wolves. And they're supposed to be exempt from emergency rules, extending time limits, really a bad law. We had kind of what you saw on a national level in the past few years in politics. We had come in 2011 to Wisconsin with the election of Scott Walker, and things got really bad here. And we're still recovering from some of these laws. I am going to go a little bit into this here. So we had a hunt in February of 2021, and it was a disaster. It made national news. It was, I'm sure, an embarrassment for the agency. It certainly wasn't an embarrassment for us. It was devastating. I mean, I sat here for 3 days crying. I think we all did. So I'm just going to kind of give you the background on what happened. So they sold about 1,500 permits, more wolves than we have in the woods, and a slaughter, which I'm intentionally using. Sorry, I lost my little spot. So was really swift. It happened in less than 3 days, 63 hours. So every 17 minutes, a wolf was being killed in Wisconsin during this hunt. And we had a quota of 100, and they exceeded that by 119 wolves in 3 days. So the tribes, by treaty law, are in ceded territory. They are allowed half the quota of wolves, but the state giving them that half was fruitless because the hunters exceeded that quota. And that equaled about 20, and low estimate, 20 to 40% of our wolf population. And the cultural benefits to the tribal community were diminished. Their treaty rights were diminished. It was a crippling loss of animals for us. And the Wisconsin Department of Natural Resources came up and admitted they had made a calculating error in their model, which allowed for this to happen. Although that hunting season was really brief, one of the important things is that it took place during our breeding season of wolves. So the impact was not just limited to this current generation of wolves, right? It also was what they call recruitment, the wolves that are going to replace any wolves that you would kill during the hunt. There was a small sample of wolves donated that were killed in that season, about 22, and it showed massive hemorrhaging and bite marks from dog fighting. And many of them, the impacts, the females all had fetuses. So that was the next generation of wolves. And so that Greenfire group here in Wisconsin estimated that 40% of our breeding females were lost in the state of Wisconsin. This loss, could recover from pre-hunt levels, but all scientists estimate low end 2 to 3 years, probably more 5 to 7 years to make up this damage that happened during this hunt. Again, we have this mandate that mandates that we have a wolf hunt. And they started preparing right away after February to go right into and have another fall season, even though we've just lost 40% of our breeding females, that it's going to take probably 5 years to recover that number. And they wanted to go right into this next season. We advocated, we protest, we had everybody write letters to the Natural Resource Board begging for a zero quota. But of course, they did not do that. And even our Natural Resource Board celebrated this wolf kill that happens. One thing I think is important when people are talking about treaty law is that treaties don't give Native tribes rights. It gives the United States government rights on tribal lands. So I think that's important. And during the 2021 hunt and for the fall, they did not do the government to government consultation and consensus they needed with the treaty rights. And that there was a federal treaty lawsuit also filed in conjunction with ours to make sure to get that tribal declaration of wolves. Our other tribes in Wisconsin also oppose the wolf hunt, but they do not have ceded territory rights. It's the Ojibwe tribes, the Anishinaabe people of northern Wisconsin. The wolves are very important. I am not going to tell you why they're important. At the end of our presentation, I know these are going to go up. You can go directly to a YouTube video with an elder, Joe Rose, who unfortunately passed away. And what we have heard and I've heard is that he died of a broken heart from that wolf hunt, which is, I'm trying not to even choke up about it now. But there is a 20-minute video if you do want to know the Ojibwe creation story. I don't think it's my place to tell you. I think it's Ojibwe's people can tell you about it. So that is on there. But it was extremely devastating and it was illegal. And I think that's the really important thing to remember. And that being illegal and us doing everything we possibly could, we hired some good lawyers. And I am going to turn it over to Jessica. So that's just kind of the brief. I just wanted to give you a background of what happened. And I will tell you that 86% of the wolves killed were killed with dogs and snowmobiles. And like I said, there's no way that you put Canaan on Canaan and it doesn't cause dog fighting. I was just thinking when listening to Fran's presentation, individuals do matter, especially when you're talking about predators. And to lose our breeding females and to lose them by being ripped apart by dogs, we were mad. And so we decided to hire litigation and we're successful. So I'm going to turn that over to Jessica. Thank you, guys.
All right, thank you, Melissa. And Melissa, our wonderful client in this case. So hello again, everyone. My name is Jessica Bloom, as you heard from Amanda and then Melissa. It's lovely to speak to you today. I am calling or zooming in from the unceded territory of the Ohlone people, which is now known as Berkeley, California. I'm going to talk to you today about the legal background for and sort of the legal landscape of the Wisconsin wolf hunt litigation before turning it over to my co-counsel, Claire, who will talk in detail about the legal theories that we used and some of the ways that other people can maybe replicate our success in Wisconsin and other states. So we'll talk about in context, the federal case, the tribal litigation, something we refer to as the Hunter Nation case, and then our wolf hunt lawsuit. And so we can advance the slide. So I think just thinking about this, the timeline of events is always important. So I put some key dates on this slide as I sort of talk through this. You all know the United States Fish and Wildlife Service published a final rule that removed the gray wolf from the endangered species list on November 3rd, 2020, which took effect then on January 4th, 2021. Several wildlife conservation groups immediately filed a lawsuit to restore the gray wolf's protected status. But 1 month after the U.S. Fish and Wildlife Service published that rule, on December 4th, the Wisconsin Department of Natural Resources, which I'll refer to as DNR throughout the rest of this presentation, announced that it had to comply with that wolf hunt law that Melissa mentioned before, and that to comply with the law, they would host a wolf hunt in November of 2021. The law itself technically says that the wolf hunt must be held between the months of November and February, the moment the wolf is delisted. And so the DNR announcing that it wouldn't comply with the statutory mandate until the following November, skipping that winter of 2021, greatly angered hunters. So on February 2nd, 2021, Hunter Nation, Inc., which is a Kansas-based hunting rights organization funded by Ted Nugent, among other prominent anti-wolf, anti-wildlife, pro-wildlife slaughter individuals and organizations, filed a suit in Jefferson County Circuit Court, which is a conservative area of Wisconsin, alleging that the wolf hunt law required the DNR to hold a wolf hunt immediately that February in order to comply with the wolf hunt statutory provision that says the hunt must be held between February and November. So they filed that lawsuit on February 2nd, seeking emergency injunctive relief. The Department of Natural Resources and the Wisconsin Attorney General opposed it, arguing they had until November. And on February 11th, that Jefferson County Circuit Court held that they lost, that the Department of Natural Resources had a, quote, plain and positive duty to hold a wolf hunt immediately. The court issued a writ of mandamus, which is a way to mandate government action, compelling the DNR to hold the wolf hunt before the end of February. That meant the DNR had to rush, and they scrambled. They went to the Wisconsin Natural Resources Board on February 15th, just 3 days later, to have a special meeting to determine how to comply with the court order. DNR recommended that the board approve a quota of 200 wolves from non-reservation lands for that first February 2021 hunt that would have to be held within the next 13 days. The DNR recommended that they issue 10 permits for each wolf under the quota. And they acknowledged there was a lot of uncertainty with this quota recommendation, that it had not had time to obtain public or tribal input, consult with its wolf advisory committee, or properly analyze the hunt's impact on the state's wolf population, which hadn't really been analyzed or looked at in 20 years. Nevertheless, the board unanimously voted to approve the quota of 200 wolves, but it went ahead and increased the number of licenses to be issued for each wolf in the quota from 10 to 20. And in accordance with federal treaty law, the Ojibwe tribes exercised their right to claim 50% of that quota within land ceded to the United States, meaning that the actual number of wolves to be killed would be 119, and it was a little less than 50%. So they would protect, the Ojibwe tribes and announce their intention to protect 81 wolves rather than hunting them, leaving 119 wolves to be killed through the public hunt. DNR sold 1,548 wolf hunting licenses between February 16th and 21st, 1,548 licenses to kill 119 wolves, setting up an absolute disaster. The hunt season began on February 22nd, and by 10 a.m. the next day, DNR staff had ordered 3 of the state's 6 wolf zones to be closed because the quota had met. DNR ordered the remaining zones closed just 5 hours later at 3 p.m. But in accordance with the wolf hunt law, these closures could not take effect for 24 hours, so wolf hunting continued. In addition, under the emergency rule that was in place, hunters had 24 hours to report their kills to DNR. So multiple social media posts showed hunters urging one another to exploit that timeline by delaying their registration of kills until the very last minute to keep the season open as long as possible and maximize the number of wolves that would be killed. At the end of the bloodbath, that one DNR staffer called a effing abomination, hunters have reported that they killed 218 wolves in 60 hours, exceeding the non-tribal quota of 119 by 89 wolves, or 83%. Hunters, as Melissa indicated, were allowed to use hounds and snowmobiles to chase wolves. And other types of abhorrent practices included hunters would go look for wolves in hunting parties that maximized their ability to find as many wolves as possible and kill entire packs, because each hunter was allowed to take one wolf. So if they had 15 people with them, they could kill an entire pack upon locating it. DNR experts and scientists agree, as you know from listening to Fran and other scientists, that the real death toll from any hunt far exceeds the amount that's reported because of the injuries to wolves. And again, reiterating what Melissa said, all scientists estimate that February hunt directly reduced the Wisconsin wolf population by at least 30% to 700 wolves. Because the DNR had so poorly managed the hunt, the tribes were unable to set aside their portion of the kill quota to protect the wolves that they deem sacred in their culture. Almost as soon, and then we'll click ahead there, Melissa. Almost as soon as the February 2021 hunt ended, DNR was planning to host their November hunt. So even though they'd been forced to host that February hunt, and the wolf hunt law requires an annual hunting season, they remained committed to their prior decision to host a November hunt. On July 26th, DNR recommended to the Natural Resources Board that they adopt a conservative quota of 130 wolves for the November hunt. Again, this estimate was based on hardly any information related to the population, the effects of the prior hunt on birthing packs and litters. And the board received 1,000 written comments on the recommendation, heard testimony, and then voted against DNR's recommendation. I think it's important to note the politics a little bit here, because that August 11th hearing of the Natural Resources Board in Wisconsin was led by the chair, Frederick Prenn, who was appointed to the board by former Republican Governor Scott Walker, who's famous for executing a number of conservative priorities in Wisconsin. He was confirmed by the Senate for a fixed term of 6 years, which would have ended on May 1st, 2021. So before this August 11th hearing. The next governor, who was a Democrat, Governor Evers, appointed a successor to Prenn, but the Republican-controlled Senate refused to schedule a hearing and give advice and consent on her appointment. And so Prenn refused to vacate his seat and just was a holdover appointee during this time period. And one of the stated purposes he gave to the press for his decision to hold over was to ensure that wolves were killed in Wisconsin. That decision, his decision to remain a holdover appointee, has been since upheld by the Supreme Court of Wisconsin. The Supreme Court has sanctioned the notion that a holdover appointee need not vacate their position until the legislature provides advice and consent for his replacement. So that means he is indefinitely going to be the chair of the Natural Resources Board until he decides to retire, or until Wisconsin Democrats can win back the legislature. At that August 11th meeting, the board members engaged in a bidding war of sorts, with the vice chair recommending a quota of 504. Now recall that the DNR had recommended a quota of 130. The vice chair's stated rationale for recommending a quota of 504 was to ensure that when the tribes claimed their protected allotment, that hunters could still kill at least 300 wolves. Others suggested lowering the quota to 300, but nobody on the board considered or desired to adopt the DNR's recommendation of 130 animals. They thought that was far too low. Anyway, because of the political volatility of that meeting and the Prenn appointment issue, DNR went ahead and defied the board, and this was an unprecedented act in Wisconsin, and went with its original quota of 130, announcing this in October. The Ojibwe tribes reserved 56 wolves, leaving 74 for the public hunt. Now, as you heard from Melissa, and we've been talking today, that hunt is mandated. But in addition to the hunt, the non-statutory provisions of the law also require that DNR adopt a rule and a wolf management plan before holding a public hunt. And now DNR had adopted its first emergency rule in 2012 when the law was passed, and then it revised that rule in 2014, but it had never promulgated a permanent rule or revisited the emergency rule. And that was at that point 7 years. As of today, on this day of this presentation, DNR still has not adopted a wolf management plan pursuant to the statute. It has a 22-year-old 1999 wolf plan, but that plan presumably was not compliant with the statute, which was enacted 13 years later in 2012. And then recently, the DNR announced that it had no intention of adopting a new wolf plan anytime soon, that they were suspending their efforts to amend and adopt a new wolf plan, which they had previously said they would be able to release and adopt by spring of 2023. So it's in Wisconsin, the state of wolf management remains uncertain. So that was skipping ahead a little bit, but back to that 130 DNR recommended quota. Plaintiffs, which were the Great Lakes Wildlife Alliance, Friends of Wisconsin Wolf and Wildlife, Project Coyote, whom you've heard, Fran is a science advisory board member too, and the Animal Wellness Action Organization, banded together, hired Claire and me, and sued the state for violation of the separation of powers, for arbitrary and capricious agency action, and for a violation of the public trust doctrine. And Mike, you'll hear more about those theories from Claire in just a moment. I just wanted to sort of let you know that on October 20, and I think you could advance to the next slide, Melissa, the parties appeared for a judge in Dane County Circuit Court, Dane County is where Madison, Wisconsin is located. So it's more of the liberal sector of Wisconsin. And so we chose to file our case there instead of Jefferson County, which is where the Hunter Nation lawsuit was filed. We filed a motion we filed a lawsuit and a motion for temporary injunction, asking the court to stop the wolf hunt. And the judge ruled from the bench the following day From the outset of his oral ruling, we could tell that Judge Frost was suspicious of DNR and potentially on our side. And at one memorable point in the hearing, this is a quote we all very much like, Judge Frost told the DNR that 0 is a number. And so they could set a kill quota of 0 under the wolf hunt law and still comply. With that quota in our back pocket, we figured we would have one, and lo and behold, we did. A Judge Frost announced his intent to sign an order that is reflected in the next slide. I'd like to show everybody exactly what we won, because I think it was sort of unique in that the judge ruled that the DNR would set a wolf quota of 0 until the DNR could do these things: promulgate a new rule for the implementation of the hunting and trapping of wolves, complied with the requirements to implement a wolf management plan, and determine the number of licenses to be harvested, applying that rules to ensure that there's no more overkilling of wolves. So a victory. It was a very exciting victory, and it turned out to be a very important victory because as we continue to litigate this case through the winter hunting season, the federal case involving the challenge to the delisting of wolves wound its way through the courts. And on February 24th, as everyone here knows, the United States District Court for the Northern District of California announced its decision reversing the Fish and Wildlife Service's rulemaking and relisting gray wolves. On March 25, the State Attorney General's office in Wisconsin, with that ruling in the bag, filed a motion to dismiss our case as being moot. We did a lot of analysis and thinking and strategy considerations about that question, and decided that we would go ahead and dismiss the case for mootness, because that would be the likely outcome if we litigated the question of mootness before the court, now that wolves were protected. And then, as I indicated, nevertheless, despite all of this litigation and our success, DNR still announced its decision to suspend the release of that wolf management plan, leaving any future decision to hold a public hunt vulnerable to a similar legal challenge. Now, on to Claire to teach us exactly how we did this and how you can potentially replicate this victory in your states. Claire is a rock star lawyer out of Washington who's done so much work in this area, and I was pleased to have her with me on the case, and I'm excited for you to learn from her today.
Thanks, Jessica. Can everybody hear me okay?
Yes.
It looks like, okay. To remind everybody, my name is Claire Lobes Davis. I'm an attorney with Animal and Earth Advocates, a law firm based in the Seattle area that advocates on behalf of domestic animals, wild fish, wildlife, and the environment. I'm zooming in from the unceded territory of the Squabosh people, which is now Vashon Island, Washington. I was really honored to participate with Jessica and her firm as an attorney on the Wisconsin wolf litigation, and delighted at the results that we were able to achieve. I want to talk a little bit today about some of the specifics of that litigation, but I want to do it in the context of state litigation generally, because the possibility of state court litigation to protect wildlife is really often overlooked. Even though states manage the vast majority of our wildlife, often with archaic policies that can be really vulnerable to judicial challenge. Jessica and I are two of the handful of attorneys who specialize in bringing this sort of litigation in states around the country, but we would love to see that expand. And just to talk about the difference a little bit, a majority of the litigation you hear about to protect wildlife is in federal court on federal claims. For example, the suits to restore ESA protection for wolves, which Jessica just talked about. That's a federal claim in federal court, as is all litigation under the Endangered Species Act. That's because federal law has some great protections for wildlife and includes some incentives to allow nonprofit groups and other people to enforce them, like the ability to recover attorney's fees. State litigation can be a whole lot more difficult. First, the law of every state is different, unlike federal law, where you can kind of learn one law and then be able to practice in different courts around the country. You really need to do a lot of specialization and intensive work to learn the law of one state and how to bring a case in that state. State courts also, each of them operate very differently. They have different rules. So when we participated in the Wisconsin suit. Since I'm from Washington, Jessica's from California, we needed a Wisconsin specific lawyer to help us out, to help us navigate the laws in Wisconsin, which are, I have to say, stranger than the laws in many other states that I've worked in. And these cases can often be really fact intensive, which means they take a lot of time and money and can be really difficult for nonprofit groups to afford. And unlike a lot of the federal statutes, which offer fee recovery, state statutes often don't offer fee recovery, or they offer really minimal fee recovery, which means that groups and attorneys need to find a way to pay to bring the cases themselves. But for all these challenges, as we saw in Wisconsin, state litigation can really sometimes pay off. There were lots of people, frankly, who were skeptical about the Wisconsin case, and other groups that had taken a pass on it as a result. But luckily, we had a group of plaintiffs that were willing to invest in that case. If we didn't, we would have had one more devastating wolf hunt in Wisconsin before the federal ESA protections kicked back in, which could have done irreparable harm to the wolf population there. There were some studies that showed that another hunt could drop the wolf population in Wisconsin below 250 wolves, which was the state relisting target, and could even result in the extirpation of wolves from the state, depending on how many wolves were taken in excess of the quota that was set. So with that background, I want to talk about the legal theories we used in Wisconsin, but talk also about the broader view of how some of those theories apply in different states, with a little bit of discussion about Washington, where I brought some similar suits in the past. And I'll do that with a caveat that it's pretty hard to generalize because, as I just said, all state law is different. So what I'm saying may not apply at all in the state where you're in, or it may be just a little bit different. But there are some general commonalities in the types of laws that most states have. So that first slide, I'm finally catching up to my slide deck here, talks about sort of the three main bases for state litigation, state wildlife litigation, wolf litigation in particular. Cases under the Administrative Procedure Act, cases that challenge a state agency for exceeding the limits placed on it by other statutes, and then constitutional claims. And go to the next slide now. Starting with the Administrative Procedure Act. Most states have an Administrative Procedure Act, which is basically the law in each state that regulates how state agencies have to conduct their business, how they can pass regulations, and how they have to behave. Fortunately, a lot of the APA acts, the Administrative Procedure Acts in different states are very similar because they were based on a single model act. Wisconsin is an outlier, which I'll talk about in a moment. But that's important because it does give us a common basis for a lot of different state claims and knowing how states need to behave. If you look to the left of the slide, and I won't talk about this very much, but almost every state Administrative Procedure Act, maybe every state Administrative Procedure Act, has procedural rules. To start with. That means that every regulation that qualifies as a rule has to go through a special process. Each state has a different definition of what a rule is. In some states, for example, a wolf management plan would be a rule and would have to go through this process. In other states, it doesn't qualify as a rule. But that process normally includes providing a draft copy of the rule to the public, allowing people to send in written comments and testify at a hearing, and then requiring an agency to thoroughly consider those comments before adopting a rule. This sounds pretty simple, and it's a process that's probably familiar to most, not all of you at a federal level, if not at a state level, but it's really amazing how often states ignore or shortcut that requirement. And it can be a good possible claim to keep an eye out for as a result, because it can be an effective way to challenge and at least delay, but maybe force a different result because the state has not gone through the proper process. Talking about the substantive requirements of the APA, though, which is where we generally see more litigation. Generally, in most states and federal government, the rule holds that agency action can't be arbitrary and capricious. You've probably all heard that phrase before. And what does that mean? It means, basically that agencies can't be irrational. They can't act without a rational basis. They can't fail to explain the basis for their action. They can't ignore facts that are in front of them. Specifically, I brought a number of arbitrary and capricious cases that argued that a state agency was arbitrary and capricious for refusing to follow its own internal policies and guidance without explaining them, for not citing any science or evidence to support its actions, or acting contrary to the science or evidence, by advancing contradictory or nonsensical claims and justifications for its actions, and failing to consider significant facts. All that behavior probably sounds really familiar to you because state agencies frequently behave irrationally. And you would think that this would be, an easy way to challenge a lot of that action. Unfortunately, the law says that state agencies get a lot of deference in this field. So it's a really high bar for us to show a court that a state agency has behaved so irrationally that they should be reversed. The general rule is that courts are not supposed to substitute their own judgment for an agency, but instead just make some sort of heightened ruling, like that no rational person could have possibly made that decision. So while an arbitrary and capricious claim is always a possibility, they're not successful very often. They're also very fact intensive and difficult to litigate. Turning to the Wisconsin case, the Wisconsin APA is a little bit different. It doesn't have explicitly an arbitrary and capricious standard. Instead, it asks generally, do the facts support the agency action? And in our case, we made I think, a very strong claim that the facts didn't support the agency action there for a lot of the reasons that Jessica and Melissa have already talked about. First off, the DNR admitted that they did not have a reliable estimate of the wolf population before the hunt that they planned in fall 2021. They hadn't, formulated any estimate after that disastrous February hunt. So any quota set without, a starting point, a reliable starting point, was going to be irrational. And I think we had a very strong argument there, but it was an argument that would have required the court to look more into the facts of what DNR did, and would have been a more difficult decision. I think that the court in Wisconsin probably would have gone there if it needed to, but it didn't need to, because as Jessica talked about, and I'll talk about more in a moment, it found kind of an easier path to enjoin the fall wolf hunt from occurring. We also challenged the flaws in DNR's analysis and data, starting with no reliable estimate of the wolf population. It wasn't transparent about how it calculated the quota and said that its quota was sustainable. It overestimated the starting population, even before the February hunt. It just did simple arithmetic then to subtract the wolves reported killed without accounting for any of the poaching. It assumed a normal breeding season, even though we knew that the February hunt, and DNR admitted that the February hunt had really disrupted the breeding season in a significant way. And it failed to account for another overkill with the fall 2021 season. But as I said, the judge did not reach these claims. He wasn't very interested in hearing about these claims in oral argument. I think they would have been, although arbitrary and capricious claims are difficult, I think they would have been strong claims in this case because the state's behavior was so out of bounds and so irrational. But fortunately, we didn't have to go there because we found an easier path, which takes us to the next slide. State court challenges based on statutory limits to agency power. And in general, the general principle is that all state agencies only have the power delegated to them by the legislature, and they can only operate within those boundaries, kind of no more and no less. So their conduct can't be contrary to the governing rules and statutes. there are many different statutes that normally apply in states that you see commonly in different states. One is a state environmental policy act or something similar. That's very similar to the National Environmental Policy Act. It basically requires states to examine, environmental impacts of their actions, often do an environmental impact statement whenever an action could have a significant impact on the environment, including wildlife. We didn't bring this claim in Wisconsin, but I have brought it a couple of times in Washington related to state wolf killing in response to wolf livestock conflict, and would like to and intend to bring it again. Because in Washington, for example, we have a wolf management plan that was done in 2011. It hasn't been updated since then. There was an environmental impact statement in 2011. Obviously, a lot has changed in science and knowledge about wolf populations since that time. And most importantly, the wolf management plan never examined the impact of killing wolves for wolf livestock conflicts or having a wolf hunt for that matter. The plan indicated that kind of analysis would come later, but it never did come, yet the state started to have a policy of killing wolves for wolf livestock conflict. So that's a prime case where you can challenge a state action under failure to comply with the State Environmental Policy Act. In Wisconsin, however, we were able to make a challenge under the authorizing and controlling statutes. In this case, the law that requires a wolf hunt every year, we were able to look at the details of that law and actually turn that to our advantage and find ways that the DNR had not been complying with that specific law that told us how it needed to set the annual wolf season. First of all, we made an argument that didn't catch on, which is that the wolf hunt law says that DNR shall have a, quote, single annual open season, unquote. They'd already had a wolf season in February of 2021. They wanted to open another one in fall of 2021. That's more than one single annual open season. But that's not an argument that the judge seized on, but I think it would have been a strong argument if we'd gotten to that point. The two arguments that Jessica's already touched on that the judge found more attractive and an easier basis for a ruling was that the state was not adhering to the instructions in the wolf hunt law about how it was to set a quota each wolf season. The wolf law required the introduction of permanent rules within 8 months of its passage in 2012. And as Jessica told you, the state had been operating under an emergency rule that was nearly a decade old. It had promised to enact a permanent rule in 2014 and did not. It had promised to enact a permanent rule in 2021 before going forward with the 2021 wolf hunt season and did not. So instead, it was proposing that it go forward again under this emergency rule that had all sorts of flaws, such as the delay in the reporting requirement that almost guaranteed that the state would exceed the wolf hunting quota. And the law really doesn't provide for emergency rules to last that long. As that the name implies, emergency rules are short-term rules that don't require the same sort of notice and comment procedures of a permanent rule. And second, the wolf hunt law required that an updated wolf plan be in place. But as Jessica explained, Wisconsin didn't have an updated wolf plan for the past 22 years and still has not updated its wolf plan. So the judge, found a way to reconcile these requirements of the law with the law that required there to be a wolf hunt every year. And the key to that was the quote that we showed you earlier, which is the judge's finding that 0 is a number. So he made an order that, even though DNR was required to set licenses in an even number every year for wolf hunting, that it was required to set those licenses, that quota, at 0 until it had complied with the other portions of the law by adopting a new wolf hunting rule, implementing a new wolf management plan, and determining the quota with reference to the rule and the management plan. If we can go to the next slide, I'll touch on this last bit just briefly because I see we're running short on time. One state claimed that, we've been looking really hard at, as I know a lot of other attorneys have been, and, advocates as well, is a constitutional claim under the public trust doctrine. Basically a doctrine that says that state has to manage wildlife as a trustee for the public good, both current and future generations. That law is very different in every state, so it requires really a state-by-state analysis, but we had a strong basis in Wisconsin to bring that claim, which has a fairly strong statement of the public trust doctrine, which ironically had been reinforced by a 2003 constitutional amendment guaranteeing the constitutional right to hunt, because you can't hunt and have a continuing right to hunt if there isn't a preservation of wildlife populations. Not necessarily the most savory argument to make, but it was an argument that helped reinforce the supremacy of the public trust doctrine. So we did make that argument in Wisconsin that another fall hunt would have been a betrayal of the public trust, and that the wolf hunt law violated the public trust because it required DNR to go ahead with a wolf hunt whenever wolves weren't listed under the ESA, even if it thought it would be a bad idea, which was the case in the February hunt, even if it thought it would endanger wolves in the state. So it required DNR to act contrary to the public trust by holding a wolf hunt no matter what. And then looking at the specific facts here, it required arguably another wolf hunt in fall 2021, even after there had already been a really disastrous wolf hunt earlier that year. The judge shied away from that theory as well. And I think he did so, I'm speculating here, but I think this was a judge who really wanted to come to the right result here. He did for reasons that I think should give advocates some pause in bringing public trust arguments in other states, especially states with really conservative Supreme Courts or really conservative legislatures. Because if you succeed in that kind of argument, it's very likely to go to the Supreme Court. So you have to look at the court politics in each state. And if you succeed on an issue as controversial as wolves in a conservative state, then it's very likely that your win could be immediately counteracted by the legislature, by a legislative finding that something doesn't contradict the public trust doctrine, trying to limit the public trust doctrine. And that could put you really back at square one and make it harder to bring other cases under the public trust theory. There are other potential constitutional claims, and we actually considered some others in Washington, including that if the wolf hunt law had actually allowed continued implementation of annual wolf hunts under emergency rules, that would violate the state separation of powers doctrine. And that goes back to the idea that the legislature delegates authority to agencies with the understanding that they're going to comply with the safeguards of the regular rulemaking process, the public notice and comment process. And if a agency fails to do that by, for example, using an emergency rule that doesn't require those safeguards for a decade, then that's a separation of powers requirement. The judge worked really hard, I think, to find a way to navigate away from constitutional claims, however, that would have automatically been appealed in Wisconsin, to come to the ruling that the DNR's activities had violated the statutory requirement, which is a much simpler ruling that allowed him to issue a preliminary injunction in a way that could not be immediately appealed to the Supreme Court. So I see I'm a little bit over on time, and I want to allow some time for questions for everybody. But hopefully that will help give you an idea of the arguments that we made, not only in Wisconsin, but also of arguments that can be made in a lot of other states related not just to wolves, but litigation on other wildlife topics, because we need more state wildlife litigation. We need more of that type of thinking in order to rein in, really out of control state agencies.
Okay, thank you, Jessica, Melissa, and Claire. For attendees, you can enter questions in the Q&A and we will ask them. I have a few questions. One for Claire on what you just talked about. How is not updating the Wolf Plan for over 22 years not illegal per the Administrative Procedures Act? And if it is illegal, how can a judge not find that irrational?
Well, so in Wisconsin, it was found to be illegal, not under the Administrative Procedure Act, but under the wolf hunt rule. The rule that required there to be a yearly wolf hunt also required that this hunt be conducted with reference to an updated wolf management plan. So we succeeded on that claim in Wisconsin. It really depends on the laws of the state, whether or not there's a requirement for an updated plan. That was a nice part of an otherwise horrible law in Wisconsin. It at least required an updated plan. Many states don't require there to be an updated plan, but it is a really strong arbitrary and capricious argument that if you're managing wolves based on a 20-year-old plan, 20-year-old science, 20-year-old population metrics, that you can't manage wolves in a rational way. So I think that's a good argument to look at, both looking at whether or not your state requires an updated plan and thinking about the irrational conduct of managing with a plan that has not been updated.
I have a question for Melissa. As the nonprofit client, how did you go about figuring out that there was a legal strategy to pursue and develop partnerships with the other plaintiffs?
Well, we knew because you've got your ways to do things, right? You can do your public comment, you can talk to your legislator, you can talk to your governor, where there's litigation. And we worked really closely with scientists. Adrian Trevis helped greatly. And other scientists, we've been thinking about this for a very long time. Unfortunately, and this will sound bad, and I don't mean it this way, it was kind of a perfect storm came in at the right time, right? Like even the agency was ashamed of what had happened. And so I've actually known Jessica, and I think this is one thing that is really cool. I met Jessica 9 years ago at Speak for Wolves, and we became friends. Really good friends, and we've worked on litigation challenges with her before on bear hounding and other hunting and trapping in our state parks. So I think this is a really good networking opportunity. So I do want to thank you for that. But I mean, that's how. And I think it's attending things like this and listening to everyone's presentation and getting to know one another. And I think that's when she was with Animal Legal Defense Fund, and now she's with Greenfire. But that was how. And so, and then through Jessica, I met Claire. And so it just kind of works out that way. I do really quickly, I thought about something that kind of pertains to your question here as well. The one thing I think is really important with a big consider, because this cost us, this was hard. It was hard to raise the money. It was a ton of work. I have no idea. But what else can we do sometimes when we're in this type of position, right? I mean, even now, like Jessica and Claire were saying with our wolf management plan, okay, like our organization sits on the wolf management plan committee. The wolf management plan is sitting there and it's done, where they're getting some social science things, but why are they not doing that plan? I think they feel a little more empowered that we sued the agency. And that, I don't know that they necessarily took, wildlife advocates as seriously. It costs the state money too, right? Not just us, with the Attorney General. And they are not doing it because that Dr. Pren, I don't know what it is with dentists, you guys, but the dentist, Dr. Frederick Pren, he's a dentist. He refuses to sit down. So, we put out a release saying, they're suspending the wolf management plan, not because they want something bad to happen within the agency. They are suspending it because of politics. Like, we are just in a jam here. So I think that's kind of a unique position. Politically, we have no moves. We are held hostage by our Supreme Court and by our legislators. We got Tony Evers, and please don't, gosh, I hope he wins again. But, I think the fact that even our Attorney General didn't They didn't appeal the decision. I kind of think that they're on our side, and maybe a little bit more than they ever were, but definitely they know that we're watching and what we're capable of. I think that's, even if you lose a case, that's what I think is really important, is that you've got to show that your grassroots organization or you as an individual, you're not going away when they tell you we don't care about you, or they don't care about your public comment. So I hope that sort of answered your question. Sorry, I went a little long.
That's all right. That great to hear that you met at Speak for Wolves, one of the early ones, sounds like. We got several questions related to Idaho and the Northern Rockies. So are any of the Northern Rockies states using your case as a model to look for strategy and success?
We are certainly trying to do that. Claire and I have been meeting with organizations in those states and trying to get them on board with pursuing some sort of litigation strategy there, while the feds and the state of Utah randomly appeal the relisting decision, just to protect wolves in those Great Lakes state, or in those Northern Rocky states, because they aren't protected federally at this point. And so if you or anyone know of organizations that would be interested, please put them in touch with either Claire or I. We are trying to put together a coalition similar to what we did in Wisconsin, and to get something going there. I think Claire has her hand up. Do you mean to have your hand up, Claire?
I do, yeah. I just wanted to follow up on something that Melissa said, because I think it's really important. It can be really difficult in response to the question to know whether you have a legal case. And that's one of the other obstacles to being able to bring state litigation. And Jessica and I are working on some plans that I hope will, put together a program that'll make it a bit easier to overcome that barrier, and at least have attorneys look at your facts and see if perhaps you have a case. As Melissa described, the perfect storm in Wisconsin, the worst facts for wildlife often mean you might have the best case to bring for wildlife. So the worse it is, the better, but that's no guarantee. But I just wanted to make a pitch for what Melissa said at the end there, which is, it's important to sue your state even if you don't win, because state departments of fish and wildlife aren't sued very often. So they're really sloppy. And, one or two lawsuits just to know that groups are watching, that they're going to hold them accountable to the laws, really does wake them up. And I've sued the state of Washington, I think 6 times now for its wolf management policy. I haven't won any of them, but it has dramatically changed the wolf management policy anyway. The way they make decisions when to kill wolves for livestock conflicts is much, much better, much more disciplined than it was a few years ago. And as a result of the threat of litigation, they've even passed on killing wolves a couple of times. So Wisconsin was really a great success, but that shouldn't be the barometer for bringing state litigation, in my opinion, because it's worth bringing even if you lose and you have kind of a feeling of futility, because it's not futile in the long term to wake these state agencies up and know that we're really watching them and we're going to hold them accountable.
Great, thanks. Then we have 2 similar questions. What about changing the Wisconsin state law? And for folks who reside in the Midwest, how can people outside of litigation get involved to stop this in the future? What's the next step?
We did. We actually did try to get a modifier on that wolf hunt mandate that I showed you earlier in the slide, and of course it died in committee. So changing the language to saying, that they must to they can, or they shall if they want to. Trying to get that mandated hunt mandate word removed. I've tried. I can give a big shout out to Megan Nicholson here in Wisconsin with Humane Society of the United States. Her and I, we keep doing it. Tim Carpenter, who actually is a Democrat here, who never even cared about wildlife, really. That's another thing too. I think, when you're getting active like this, send public comments. I know sometimes it might not be effective if you live in Montana. You better believe that I send a public comment to Montana and to Washington and to Idaho and to everything I need to do, because most of our wolves in Wisconsin reside on public land, federal public land. These are everybody's wolves. And as Claire was talking to you guys about the public trust, that's not a state by state. They may be asked to manage that public trust asset, but that's federal. And these are all of our wolves, whether you live here or not. So, check out our action alerts. Visit our webpage, see the work that Claire and Jessica are doing in other states. And I don't think it ever hurts to call me up or email and say, what do you need, Melissa? Because I need more of that. And what we need here in Wisconsin right now, one of the other things I think is my best advice and how I personally failed. And I'll tell you, I failed wolves. That wolf hunt happened because we were relying on federal law. Okay. And while, yes, it's so important to have these national coalitions, make sure you are not relying on ESA protections for any species into the future, because we were not paying as close of attention as we should have been on a state level, because we're like, whoo, wolves are back on the ESA. Let's go do something else. I will never take that for granted again. So I think that's something really important to make sure you're getting involved with your state wildlife plans. Show up to the meetings. One of the things I can say, and I'm not being negative towards you all, I'm just trying to motivate you. Hunters and antelope people show up. Now, granted, a lot of them are older, like boomer generation. They don't have to go to work. I understand that. But with Zoom and all these opportunities, that is the criticism. I heard it from my DNR secretary. You guys don't show up to these things. So I think making sure when your wildlife committee meetings are happening, knowing what's going on with your management plans for all wildlife is crucial if you want to make change. And yes, well, of course, we want wolves on the ESA. We don't believe that they've recovered here all the way. That's not what I'm arguing. But I think I did become a little lax relying on the Endangered Species Act, which is not really intended to stop hunting and trapping. It's just not. And whether I think we're using that how we should, I think is debatable, but you definitely should be getting involved with your wildlife commissions or natural resources board, even if you just go there and eat a box of donuts in front of them to protest bear baiting like I did last month. So definitely do that and get involved.
Great. Thank you so much. Yeah, we definitely agree. Get involved with your wildlife agencies. And we have on our website a page where we link to all the different states that have wolves wildlife agencies. So really important point. Thank you all for speaking today and for doing this legislation. We really appreciate that you did it and that you were successful, and hopefully it's a good model for other states going forward.